I'm Rutuja Kulkarni. I'm a director of Brainiac Global Consulting Private Limited and also heads the Trademark and Design Department in Brainiac IP Solutions. I have completed my education in microbiology and I'm registered Indian trademark agent. I'm having experience in the IPR industry for over a decade now. In Brainiac, I guide my clients on various aspects of trademarks, from starting from the trademark filings till the trademark registration and even enforcement of those registered trademarks. I also guide the clients in India as well as internationally. And I also guide my clients on various aspects of patents, designs, and copyrights as well. So these are our two companies, Brainiac Global Consulting Private Limited and Brainiac IP Solutions. So we are in the IPR industry from last 14 years now, and we are working with more than 2,500 clients from India as well as from US. So these are the few recognitions and few awards that we have received for the excellence of for the excellence in our in this industry. So coming back to the topic, as a business owner, why do you need a trademark? So please comment in chat box why you want to file a trademark, why you want to get the registration on trademark. So why do you need a trademark as a business owner?
Hello.
Brands. Yes, yes.
Are we supposed to speak or on this?
No, you can write down in chat box. Even if you can speak, that is also fine. You can unmute yourself and can speak. No problem. Yes, Mr. Suraj is saying brand safety, right? Piyush Rajput saying protect our brand from infringement. Yes, exactly. Protect, monetize, and branding or credibility. Yes. To protect our business, products identity. Yes. To protect the brand name. Yes. Brand uniqueness. Yes. Yes. Definitely. So just imagine a situation that you have started a business with particular name. Now you have received the recognition in the market. You have built a brand around that particular name. And after a few years, you realize that this name is already existed in the market in someone else's name. And that person is now want you to stop using this mark, this name for your business. And now you need to withdraw that name or you need to change the name, and now you have to again rebrand yourself, your business in the market. So this is the completely loss of your investment which you have invested till the date for recognition of your brand. Also you have to face the infringements. Then if that person claims the damages, then that is also a problem. And you have to again invest on the rebranding. So it is a loss of financial, it is a loss of money, as well as there is a loss of mental peace. So this is a quite chaos in future that you can face. So always before starting any business, the trademark registration is always a first step you should take, and you should follow that first step very carefully before starting any business. So this is a example that that is I'm taking. So tandoor chai or matka chai. So let me clear, I'm not promoting any chai business or something. I'm just taking this example purely just so everyone can understand what I'm going to say now. So it is a chai, if you want to start some chai business and now you want to have some, you want to give some name to the chai business. So if you prefer to have give the name only chai or something around the chai, then the trademark registration is quite difficult, because the chai is a very common word. Commonly people knows that word or says that word. So it is quite difficult to get the registration on that particular chai. So what people generally does, so you must be knowing the MBA chai wala. This is the very famous chai wala. Nowadays, people are inviting him for speeches, and he's some speaker now. So this is some brands, MBA chai wala or chai bolo chai, BBA chai wala. So what does these people does? They come up with the some device mark. What is device mark? It is a word plus logo, or you can say it's only you can file trademark for only logo. So generally the trademark registration or that particular logo gets protected under trademark registration, and you will get the protection on particular design element. But it is very difficult to get the protection on that particular word, that is chai, for chai business. So it is very generic word, and so the trademark registration for generic words is very difficult. And if you want to go for such names, so it is always better to come up with some design or some logo along with the word. So okay, you can get the better protection. So what is a trademark? So according to the Trademark Act 1999, a trademark is a sign that individualizes the goods. Sorry. Very sorry for this technical glitch. Actually, I'm not that much techno savvy, so I'm facing this problem. Yeah. So, according to Trademark Act 1999, the trademark is a sign that individualizes the goods or services of a given enterprise and distinguishes them from its competitor. So, it is basically trademark is a sign or logo or a name of your business or products, or maybe shape of goods or packaging or combination of colors, or label, ticket, name, signature, whatever it is. So it is a basically can protected under trademark, and this can be a distinguishing, or it can be your brand identity. It distinguishes your products or your services from others in the market. So what can be protected under trademark? So name of the businesses. So you can see here the Coca-Cola, Philips, Apple, Nestle, Toyota. These are the names. So particular words can be also protected under trademarks. Excuse me. So specific words that can also protected under trademarks. So if you are giving some name to the business and that is only a word mark, then it can be protected as a word mark in the under trademark. So these are the logos. So looking at these logos, you immediately get to know which is the brand. So these are the recognition of those brands that got the recognition for those logos only. So that design element they have used to protect. So that design element got the recognition, and so just looking at these brands, we get to know that this is a Audi, Toyota, Tata, Jaguar. So these are the logos. So that these logos can also protect under trademark. So these are the non-conventional trademarks. So there are some trademarks which can be protected as a color mark, sound mark, smell mark, shape mark, holograms, motion marks. So color marks means any specific color combination that you are using for your trade or for your word mark or for in your logo, so that can be protected under color mark. So any specific color combination can be used, and that color combination will be the will use always used as your identity. So that is covered under color mark. So there is a sound mark also can be protected. So any sound that you are using, that particular sound can be protected under sound mark. So the voice of Harley Davidson, that is protected under sound mark. Also, if you remember the roaring lion of MGM production, that is also a sound mark, and that is protected under sound mark. Even the Nokia's ringtone, that is also protected under sound mark. So smell mark also known as saint marks. These saint marks are not that often, not that common in India, but in US and Europe, there are many smell marks are already registered. So smell marks are quite difficult in India because the basic thing of the trademarks is that it should be represented, and the smell marks are quite difficult to represent or in paper format or something. So it is not possible to represent a particular smell of any product, so it is quite difficult to get the protection on smell marks in India. But in US that are the common, and in Europe there is no requirement of representation. So in Europe also there are a lot of marks which are protected under smell mark. The famous smell mark, you can say the tennis ball having the freshly cut grass mill. So that is covered under smell mark. So shape mark, so any specific shape of that particular product can be protected under shape mark. So if you know the Toblerone, that the chocolate having that triangular shape, so that is covered under shape mark. Also the Coca-Cola bottle, the earlier they used that glass bottle, and that the shape of that particular glass bottle is covered under shape mark. So there are some holograms that are also covered under, that are also protected under trademarks. So any 3D images that you can create, that can cover under holograms, and that can be protected under trademarks. So that Toblerone packaging, that is 3D packaging, are protected under holograms. So motion marks, animations, if you are creating some animations for your business purpose, so that can also cover under trademark and can be protected. So these are the most valuable brands in India. So Tata Consultancy Services have a 45.52 billion US dollars value, brand value. So these are the some HDFC Bank, Infosys, Airtel. These are some brands which are having a very recognizable brand value, and they have created a very huge brand for themselves. So well-known mark. So there are few marks which are covered under well-known marks. So these marks are very well known in the market, and they are existed in the market since long, and they have the good recognition in the market. So no one can copy them, or no one can use that name for any of the business or any of the products or any of services. So there are these. Earlier, the government themselves can introduce the well-known marks, and they can cover that particular marks for their popularity and for their recognition in the market, and that can be listed in the well-known mark criteria. But now, if you want to cover, if you want to add your trademark as a well-known brand, you want to create as a well-known brand, then you can file an application to the trademark registry. But there are some criteria, so you have to provide a lot of documents to get your mark listed in the well-known trademark. So trademark registry can examine the mark, and if they are satisfied with the all the evidence, and they feel that all the criteria are fulfilled, then they can add your trademark in the well-known list. So the most common criteria are your mark must be registered in minimum of 2 classes at least, so that and also there is a huge recognition, and there should be a good recognition. There should be a promotion in the market, so that recognition in the market. So the public should know your mark, and there is a huge promotion of that trademark. So that can be also criteria. Also, if your trademark is registered, then how seriously you enforce your registration, how seriously you take the you start infringement cases, or you send the legal notices to your competitors who are copying your trademark. So those things are also taken into consideration while finalizing the criteria for well-known mark. So you can file an application. There is a fee of 1 lakh rupees that you can file an application, pay the fees, and then you can provide all those evidence. Then trademark registry examine the mark, and if they find that all the criteria are fulfilled, then your mark can be listed under well-known trademark. So most common or most important factor of well-known trademarks, that if it is a well-known trademark, once it is listed as a well-known mark, then no one can copy your mark, or no one can use that particular name for any of the business or for any of the products, for any of the services. So you can say Tata is a well-known mark, so no one can use that particular name for any other services or any other businesses, any other products. So your mark will be a this well-known mark can be protect your mark, and no one can copy it. How to select a good mark? So there are many criteria how you can select the good mark, because if you use any common names for your businesses, if you use any dictionary names for your businesses, these names are not at all registrable under Trademark Act. So what are the good marks? The distinctive marks. Distinctive marks means the marks which are distinct your particular identity from the others. So these are not the common words, these are not the dictionary words, and these marks can distinguishes your products, your existence, your services from others very easily, and it can be recognized in the market very easily. So these type of trademarks can be considered as distinctive marks, and these distinctive marks are very good marks to get the registration very easily. Then capable of graphical representation. So whatever marks you are going to choose, whatever names you are going to choose for your business, that should be graphically, that should be able to represent graphically. So if you want to any name that you want to write down on paper, you should be able to write down on paper, or you should be get a print of that particular name and you can show it. So that is the graphical representation. So those names should be the represented graphically. So the names which are easy to speak, easy to spell, and easy to remember. So these such kind of marks are considered as a good marks, and such marks can get the trademark registration easily. So invented or coined words. So any dictionary words cannot be protected under trademark, but if you get the two different words from, even if one of these are the dictionary words, but if you are getting those words and you are combine those words and come up with some other word which is not there in the dictionary, then such marks can be considered as invented or coined words, and that has a very good chances of getting registration very easily. So Infosys can be a good example. So it is an information system, and they have these two words, they get together and come up with the word Infosys, and Infosys is registered. So such kind of marks are very easily get a registration. Even Nike, you can say Nike or Kodak. So such names don't have any dictionary meaning. These are completely coin words. They don't have earlier existence in anywhere. So these types of words can get the protection easily. So what are the bad marks then? Then phonetically similar marks. Phonetically similar marks are those marks which can be, sorry, which can be sound same. If 2 marks, even the spelling will be different, but at the end, if pronunciation of these 2 marks is the same, then this can be considered as phonetically similar. For example, if I am using the word picnic, I am using the spelling Piknik, and another word is picnic, which is Picnic. But at the end, the pronunciation of these 2 marks is the same, that is picnic. And in that case, it is considered as a phonetically similar marks. Even there are some marks which are partially similar, means any like Bata foam. So Bata is particular one brand, and if Bata foam we consider, then they have covered that Bata name in that particular trademark. So it can be also considered as a phonetically similar mark because they have partially covered that particular trademark, and so they can create the confusion between the public, that public can think that this mark is from Bata itself. So such kind of marks are considered bad marks as they don't get registration easily. So geographical names. So any geographical areas, any geographical locations cannot be used as a trademark. Such marks cannot get registration under Trademark Act, because if I'm using India or Bharat in my trademark, so I cannot establish any monopoly on that particular name, India or Bharat. I cannot say anyone that you cannot use word India, and I am having that monopoly. So such geographical names are not protected under Trademark Act. So self-praising words. So self-praising words are the words which itself describes the quality of that particular words. So words like fresh, best, super, excellent, such kinds of words are the self-praising words. They itself shows the quality of that particular product. So such kind of words, if we are using as a part of our marks, then such trademarks are not get protected easily under Trademark Act. It is quite difficult to defend them, or it is quite difficult to show that these products are not praising themselves. So such kind of marks are very difficult. So deceptive marks. So deceptive marks are the marks which are the very deceptively similar with the other marks, or they can copy their representation of that particular mark or color combination of that particular mark, and showing, though it is a name, different name, but the showing very much resemblance with the earlier mark, then these marks are called as a deceptive marks. So there is a very famous case, that Starbucks and Sardar Bucks coffee. So if you can see the Starbucks coffee, the logo, that logo of the Starbucks coffee and the logo of Sardar Bucks coffee is very much similar. Even they have used the same representation, they have used same color combination. So these are considered as a deceptively similar mark, and such marks are such marks considered as a bad marks which cannot be protected under Trademark Act easily. So advantages of registration. So when the application is filed for trademark, it is you can start using TM over your trademark. So it denotes that this particular trademark is under process and it is filed. But once that particular trademark is registered, then you can start using R, which denotes that particular trademark is already registered. So what this registration of trademark, it gives you a particular set of rights. So if you have a registered trademark, then you have that rights, that you some exclusive rights of using that trademark. So only you can use that trademark. Without your consent, no other person can use that particular trademark for that particular goods or particular services. you can restrain others for using that particular mark. So for example, if I'm having a trademark on my company name, that is Brainiac, so I'm using that mark particularly for the services, consultancy services, legal services. So all those, for those services I'm using that mark. So any other person if uses the same mark like Brainiac for this in the same class or for the similar services, same services, then I can stop them easily as I have a registration on that particular mark, and I can stop others using same Brainiac for the same services. There are chances that someone can use for other services or for other products, and maybe that time I'm not able to stop them. But for the same services, same products, same representation, definitely I can stop them for using the same mark. So initiate infringement proceedings. So if you find out anyone is using this same that your trademark for the same services or for the same products and creating confusion in the market, in the public, then you can definitely initiate the infringement proceedings. You can start sending legal notices. Also you can file the legal suits against them, and you can definitely get the restrain them from using that particular mark. So registration certificate, once you file the trademark, you get the registration certificate when it is get registered. And the registration certificate is a prima facie evidence of validity. It validates that this particular trademark is registered in your name or maybe in your company's name. And so you are the only authorized person for you for to use that particular trademark. And this is the prima facie evidence that you can show that this particular trademark is registered under my name, and no one can use it for the same services, same products. So it serves as a prima facie evidence when you get a registration certificate. So terms and renewal. So once the trademark is registered, it gets the protection for 10 years. And then every 10 years you have to renew it just before six months before the first 6 months before the expiry of the last registration. So it is a perpetual trademark. Until and unless you want this trademark, you can just renew it every 10 years with the prescribed fees, and it will be perpetually with you. So Madrid system. So Madrid system is the system through which you can file the trademarks internationally. So if you want to go internationally, or you have filed trademark in India and now you want to extend your business in other countries, for say you are want to go for US now, and now you want to file the trademark in the US as well, then you either can file the trademark in US directly, or there is a system called Madrid system through which you can enter to US with your trademark application. So Madrid system is a one set of application. It 130 signatory countries are there. So once you file one Madrid application, that you can designate all the 130 countries, and you have to pay some fees. But this is a one application. So if you want to amend, you can just amend the basic application. Once it is registered, you can pay the registration renewal fees for that particular one application. And it is a very simple thing, or it is a very simple application that covers lot of protection in lot of countries with a single application. So if you want to go internationally, go through Madrid system is very easy thing to enter internationally for your trademark application. I hope I'm audible to everyone. So just give me a thumbs up if I'm audible. Any problem you are facing, you are getting my voice properly? Yes? Okay, thank you. Thank you so much. So if you have any questions, you just you can write down in the chat box, or you can just ready with the question. And at the end of session, I will definitely try to answer all your questions. All your queries will be answered. So you can just wait for the end of session and you can ask your questions. Yeah. So trademark, this is the trademark flow chart. So now we will discuss the trademark procedure from search till registration. So whenever you want to go for trademark filing, the first step should be the trademark search, because without trademark search you cannot understand whether your trademark is registrable, it can get registration or not. If you will not conduct any search and you will file the trademark, and after filing, if there are already registered trademarks, then it is quite difficult to get registration for your trademarks. So the first step should always be the trademark search, and I recommend this trademark. You always work with professional for trademark search at least, because the trademark search is very crucial step and it is quite required the experience to give you a proper opinion whether your trademark is able to get registration, and what alteration can be done in your mark so that your mark get registration easily. So trademark search is the first step. So there is a Indian database where we generally search the trademark. So we check whether already registered trademarks are there with the same name, or what are the chances of your trademark registration. So second step will be once the search is done and now you are ready to file your trademark, then the second step should be the trademark filing. Once the trademark is filed, so there are three types of trademarks filings are there. Either you can file only word mark, or you can file only logo, or you can file word plus logo together. So this is called as a word mark, logo mark, or device mark. So in device, you can file the word and logo both together, and you can get the protection on both the things, word and logo. So once the trademark is filed, then the trademark registry examines your trademark. They also examine it with respect to the Indian database, and they check if any already registered or trademarks are there which are similar to your trademark. Then they come up with the examination report. Nowadays, or maybe examination report, it's quite common for the trademark registry. They generally object the trademarks, or they come up with the examination reports, because even if there is a small uh, similarity between file mark and other marks. Hello. Anyone wants to ask something, or so the generally trademark registry comes in.
Ma'am, someone from your company, I think they have unmuted themselves unintentionally.
Yes, I'll just check it. Yeah, just give me a second. Mute the. Yes. Sorry for the interruption. Yes. So the third stage is examination report. So trademark registry come up with the examination report. If they find there is a similar trademarks are already there in the Indian database, and then they object the trademarks, and then we get the 30 days of period from the date of receiving the examination report, that we can submit the examination response to a trademark registry. We can show whatever the differences between the trademarks. So what we can show the if our trademark is completely different from the cited trademarks, and we can file the response. Then if at all the trademark registry is satisfied with the examination response, then they can accept the mark. But if they are not satisfied, then the hearing will be scheduled for the that particular application. Then we can nowadays there is a virtual hearing, so video conferencing will be there. Earlier we had to go to the Mumbai trademark office or whatever trademark office will be there. So we had to go there and have to convince the examiners physically. So we have to present our response to them in physical form, and then only the hearings will in such a way the hearings could be done. But now the hearings are virtual hearings, so through video conferencing the hearings are done. So in hearings, we again have to defend the trademarks. We have to show the what are the difference between our trademark and earlier cited trademarks. So if we can show it properly and we can defend the trademarks, then trademark registry accept the trademark. Once the trademark is accepted, it gets published in trademark journal for 4 months. So in during these 4 months, any third party, if they want, they can start opposition proceedings. So opposition proceedings generally for if they find that the accepted trademark is quite similar to their trademark, and it can create a confusion in public that these two trademarks are quite similar from the same owner. Then in such cases, the third party start opposition. So in 4 months, if the trademark is opposed, then the opposition proceedings will be started. Otherwise, if during these 4 months there is no opposition received for this trademark, then trademark get registered. So, or if the trademark registry is not at all satisfied with our defense, then in hearing itself a trademark get refused. So if it is registered, then after every 10 years you have to renew it. So as I earlier said, once it is filed, you can use TM over your trademarks. And when it is registered, then you can start using R over your trademarks. The TM denotes that the trademark is under process. The R denotes that trademark is registered one. So international filing procedures. So we just now gone through the mandate process. So now I'll just give you a brief about this international filing procedure. So for international filing procedure as well, you have to take a proper search for domestic and globally. So if you want to go for filing a trademark in US, then if at all your trademark is acceptable in India, that doesn't mean that it can easily accept in US as well, because the trademark protection is a territory rights. So if it is protected in India, then only Indian database it is protected. For Indian territory only it is protected. If you want to go for US, then you again have to file a separate application in US. You have to take the registration in US, and for that, before going for the trademark filings, you have to take search in the US also. So in US database, we have to conduct the search whether the already similar trademarks are already there in the database or not. If there is no particular mark found, then we can go for the filing. So even in for infringement also, you can conduct the search in the database whether the already registered trademarks, because many times this happens that there are already trademarks, registered trademarks. So how much similarity in between your proposed mark and that particular registered trademark? Is there is these two marks are very much similar, then there are higher chances of infringement cases will be there. But there is a quite less similarity, but partially it is similar, but that similarity is not that extent, then you can definitely think of filing the trademark. But if at all the objection comes or infringement starts, then we have to defend the trademarks. So before going for filings itself, it is always better to conduct the search and take the proper opinion whether what are the chances of these particular trademarks can be registered. So once that search will be done, then the trademark application can be filed. If you can file, if you want to go for mandate application, then first you have to file it in a country of origin. What does it mean? If I'm an Indian national, then first I need to file the application in India, and after grant of that particular trademark in India, then I can file it in US through mandate application. So if you want to file a mandate application, then you first have to file it in your country of origin. If you are a US national, then you first filing should be in US, then you can file the mandate application. Then mandate applications can be filed. Then you can select the designated countries. There are 130 countries which are the signatories of mandate protocol. So if you want, you can decide whether you want to go for all those 130 countries, or there are some countries where you want to extend your business. So based on that, you can choose the name of countries while filing the mandate application. You can designate your application on those particular countries, and if at all required, we have to get the involvement of the foreign attorneys, because in foreign we cannot file the applications directly. We have to go, like, if some US national person is there, or some they want to file an application in India, they have to go through our uh, Indian attorneys for filing the trademark in India, because the US attorneys cannot file it directly in India. Likewise, the Indian attorneys cannot file the application directly in USPTO. They have to go through US attorneys. Also, the second thing is, there are many difference in the laws in Indian trademark laws and US trademark laws, or likewise in other countries. So it is always better to get that particular attorney involved in the filing, so that they can check all the compliances, and also they can check what are the chances of this registration, what and all documents we need to provide, so that there will not be any hurdles while for getting these trademarks registered. So through all these steps, we can file the trademarks in internationally also. So trademark infringement, civil and criminal offense. So if the deceptively similar trademarks are there, then definitely there is a infringement cases happens. So as I earlier said, there is a major example of deceptively similar case, that Starbucks and Sardar Bucks, as the both logos are very much similar. I'll in later slides I'll show you the logos as well, so that you will get the clarity on what I'm saying exactly. So if the trademarks are deceptively similar, means if the representation is similar, if they are copying, if someone is copying the already registered trademark at very much extent, they are using the same color combination, the representation, also there is a very much similarity between these two words, then definitely the register owner can file the infringements against those trademark owners. Phonetically similar, against Starbucks and Sardar Bucks, where is the pronunciation of these two words are very much similar. So phonetically similar cases are when there is a very much similarity between two marks, when they sounds very similar, or even if the different uh, spellings, but still the pronunciation will be the same, then these marks are considered as the phonetically similar. And definitely if the two marks are phonetically similar, then the register owner can definitely find the infringement suits against the another owner. So when there is a similar logos, so someone is copying your logo as it is, then definitely there will be a infringement suits can be filed for the similar logos. So similar trade dress or color code. So trade dress is the theme, that color theme particular. If you go for Starbucks cafes, then they have a particular color theme. So in any country or in any origin, if you go in the Starbucks, they have the same similar color theme. Even in Vodafone, Airtel, they have that similar color theme. So they always have that same, they follow that same color theme as their trade dress. So anyone can recognize that this is that particular mark, this particular cafe, Starbucks, or this particular office is of Airtel. So in that case, if someone copies that um, uh, trade dress or that color combination for their services or for their goods, then definitely it can be considered as the same trade dress, and trade dress can, and someone means people can file the infringement suit against the same trade dress or same color code if they are using. Likewise, similar packing. There is a case which is Parle biscuits. So the packaging of that Parle biscuits is they found that someone is copying their packaging, and it is very much similar. Then they filed the suit against that particular company. I think that is JP's company something. I'm not able to recall the name properly, but I think it is JP company, and they have filed the suit against that JP company because there is a very much similarity between these two packages. They are also selling the biscuits under that particular package, and they have used the same color combination of everyone knows that Parle biscuits, glucose biscuits, how the packaging is. So the packaging, the length of that particular packet, and color combination of that packaging, even words, everything was quite almost similar with the Parle packaging. So they have filed the suit and they won that case. So these are the criteria where you can definitely start the infringement against the copied trademarks. So this is how this is the one that Starbucks and Sardar Bucks coffee. So if you can see, it is a green and black combination. So here also it is a green and black combination. Just alternate the things, and also the representation of that circle, also the representation of that color combination, and again the Starbucks and Sardar Bucks, the use of that words which is very much similar with the Starbucks. So Starbucks sued that Starbucks, they have sent them legal notices, but still Starbucks continued the use of that their trademark, and so finally the Starbucks sued them and they won the case. So likewise, there are some other examples like Puma and Coma. If you can see, the pronunciation is quite similar. Also, they have used the logo just in reverse. So it is a deceptively similar, very much similar, and so this is the deceptively similar cases. Likewise, Nike and New, they also have the similar pronunciation, even if they have used that logo of Nike in reverse manner. So it is these are the deceptively similar marks. So this is also one of the case where the Bhatia Plastics, they have the registered trademark as Mayur, and they were selling the household plastic goods under that particular mark Mayur. Then Peacock Industries, they have also start selling their plastic goods under the name Peacock, and they filed for the trademark Peacock. But the Bhatia Plastics, they filed an infringement suit against the Peacock industry, saying that the Mayur and Peacock, these both represents a bird, and also the Mayur is a Sanskrit translation of the peacock, or we can say peacock is the English translation of Mayur, and therefore they filed an case against the Peacock Industries, and the temporary injunction was granted for the to Peacock Industries. They have restrained to use that Peacock name for selling the plastic goods or that particular goods. Yeah. So this is the very famous and very recent case. So this is Mahindra versus Indigo. So Indigo has filed a case in Yes, Indigo has filed a case on Mahindra saying that the 6E is a registered trademark of Indigo and they are using extensively for many services. That trademark they are using extensively, and the Mahindra is come up with the BE6E, some electric SUV, and they are using that BE6E for that SUV. And Indigo files the case against Mahindra saying that the 6E is their registered trademark and they are using it extensively. And whether it is a standalone or with the combination of other words with or maybe a any variants, but they can only exclusively use that 6E, and Mahindra can don't have that right to use that 6E, and that's why this case is still in Delhi High Court, and this is the very recent case. So this is the case. It happens to our one of my clients. So one of the US company, they are having registration over this umbrella mark. Okay, they have that logo protected under trademark, and they are in the market since 1960 or 1860 something. But this US company and the Indian company, they filed a device mark, word plus logo for umbrella, and they use that umbrella, that picture of umbrella in the O as their representation, and they are filed for the logo as well. But this US company sent the legal notices to Umbrella and they asked them to withdraw the trademark as they are using it since a long, and there might be a confusion in the public that the both the marks are from the same company, and saying that the Indian company had to withdraw their application and they have withdrawn that. So this is also very famous, very important thing to take into consideration, that whenever you are filing trademark, you have to check whether you are infringing any logo as well and word as well. So recommended steps for trademark. So whenever you want to file a trademark, coin or choose a unique word or combination of words. So if at all you are using dictionary words, then combine these dictionary words and come up with some unique words so that the trademark registration can get easily. So trademark search from experts. So work with experts, get the trademark search, conduct the search with the experts, ask them to conduct a proper search, thorough search, and then take the opinion from the experts whether the trademark is your trademark is available or there are any alteration requires to get it protected easily. Then file for trademark application, then get the trademark register, and after trademark registration go for company or product registration, because there are many times you go for company registration first, you decide some name, then company registration and product registration, everything happens, then the people come for a trademark registration, and that then they got to know that this mark is not available or this name is not available, then again changing the name and again going through all this registration process, company registration or product registration. This process is quite time taking, and also it is a financial loss. So always first go for a trademark registration. Once you have that clarity that this name is available for trademark and you will get the registration on this trademark, then go for company registration or product registration. So these are some government schemes for MSMEs and startups, to startup facilitators, and there is a 50% reduction in the government fees. I'm sorry that the professional fees has been written here, but there is a 50% reduction in government fees. But also, if you are an MSME or startup, so there are some schemes where you can file an application and you can show all your costs that you have invested in trademark registration, and you will get some say 80% of rebate from that from your government. So there are some MSME schemes are there, so through which you can get your invested whatever fees or that government fees you are invested, you can get them back. So what should be the first step? Registration of your business or company, or registration of your trademark. So after all these insights or our discussion, so what is your opinion? What would be the first step, whether registration of business or registration of trademarks? So just write down in chat box, or you can unmute yourself and tell me. So what would be the first step?
Incorporation of company.
Uh, okay. Anyone else?
Registration of business.
Now, just I'm giving you one scenario. If you register your business in with some name,
Registration of trademark.
yes, so registration of trademark should be the first step, because if you register your business, or if you incorporation certificate, for incorporation certificate you have to give some name to your business, and when you give that name to your business, and suppose at the time of trademark registration you realize that this name is already in existence, or already someone has the registration over that name, and now you cannot use that name, then again, just a few minutes back, just I told you that again you have to go through all those process. You have to change the name, then again that incorporation, again that registration of business. That will be a tedious process. So if you want to start your business, I'll always first go for trademark registration. First check whether the name that you have decided for your business is available or not. What are the chances of getting that mark registered, and then only go for uh, business registration, company registration, incorporation, whatever it is. But for always go for first trademark registration. There you always get the clarity of whether that name is whether you will get any later you have to face any infringement or not, it is a copy. Because sometimes what happens, you choose the name, you don't know whether it is a, you are unintentionally, it is not intentionally, but maybe unintentionally you are copying someone's name. So in that case, there is a possibility of further legal suits and infringements and legal proceedings. So always, to avoid that, go for trademark registration first. Yeah. So these are few of our clients from
Hello,
India.
ma'am.
Yes.
Jaya, this said actually I have to make a point here that if the trademark is for a proprietorship or a partnership, then it could be a case that first, if you are going with trademark and then with the firm name, it is okay. But if you are a company form of organization, so there's already a process of name approval in companies where the existing names are not provided to any new organization that is like wishing to establish in that particular name. So, if it is a case of company, we can go for first the company incorporation and then trademark. Am I right or like?
Yeah, actually, what is saying, when you go for company registration, earlier this process was not there, but nowadays there is a process when you go for company registration. When you enter your name, the system itself gives you the inputs whether this name is already registered or not. Means that the name is
Exactly.
already in the database for that particular company, for business, or likewise they give you inputs, and in that case also you understand that this name is not available and you are not able to use this name. But then you have to put various names, and you have to check every time, you have to follow that complete process every time, and then only you get to know whether that name is available or not. But in trademark, there is a first step is that search. So during that conducting that search itself, you get to know whether this mark is available or not, and accordingly you can go for company registration as well.
Okay. Thank you.
Yes. So these are some clients we work with. So some from India and some are from other countries as well. So these are the other services which we provide. So we provide a complete IPR consultancy and coaching. We also deals with patents, copyrights, design registration. So patent drafting, patent analytics, litigation, all obviously trademark filings, watch and litigation, corporate filings and litigation, design patent filing litigation, and IPR process implementation and mentoring. So all these services we provide in Brainiac IP Solutions. So this is our podcast channel where we invite the R&D's heads or inventors to share their insights and also the whatever the current updates about the industry. So this is our podcast channel. You can just scan the QR code and you can watch our podcast channel. In this on this channel, also there is one interview. My interview is there, which is in Hindi for trademark processing and for all the trademark queries. So you can definitely watch that. So if you want, you can just scan the QR code. So this is our podcast channel built on brains. So you definitely do watch. So I'm open to question and answer. So anyone wants to question, please unmute
Ma'am, I
yourself.
have one question actually. My company name is iSignal. Okay.
Okay.
That I already registered as a company before searching any trademark, because with my CA I already followed, and he has given he asked to come up with some 2 3 company names like that. So at
Okay.
that time I was not having any awareness related to trademark before going for the registration. So I already went for the registration process, and it's been 6 to 7 years I'm using that company name actually, and I have come up with logo right now.
Okay.
I'm not sure whether how to proceed with respect to the trademark, because I am already a registered company, and it is all I am already using, and that is unique across India.
Okay, no problem. Even if you want to go for trademark now, so you can first conduct the search. You can first go to the expert and ask them to conduct a search for that particular name. Check with what are the chances of getting that trademark registered. And as you are saying that you are using it since long now, so you can also show the evidence that you are using it since long, so that on the basis of that evidence and basis of your use also you can get the protection over that mark, even if it is not available or any similar marks are already there in the database. So on the basis of your use also you can get the registration, but it's depend how much use you have, how much what and all evidence you can provide. So for this I cannot comment immediately. Maybe if you want we can have a one-to-one meeting later for this particular things.
Okay, so that TM and R I cannot use right now, even though I registered the company and using for a long time.
No. You can use TAM only after you filing the trademark application.
Okay,
Yes.
okay, ma'am. I'll discuss offline.
Yes, sure. So anyone want to discuss any particular queries or want to discuss one-to-one, then my team will share the calendar link also. So you can just book the appointment and we can also have the one-to-one discussion if any particular queries are there, or if you want to go for trademark registration, if you want my assistance or my help in that particular process. Yes.
Okay, what will be the trademark registration charges, ma'am, from
It is for MSMEs or for startups, small entities.
I'm
It
an
will
MSc,
be,
ma'am. Yeah.
yes. So for basic charges, it will go around 8,000, up to 8,000 basic charges.
Means for the registration.
For filing
For
the trademark
filing.
application.
Okay, it is only for filing.
Yes, it is only for filing.
Okay, fine.
Okay, yeah.
Yes, madam. If
Hmm.
there is any brand is already registered, and can we have a brand registration with suffix or prefix for that brand?
It is actually depend what are the existence of that particular brand, because their brand is using their brand for a long time, and they have proper existence in the end, then there is a quite difficult or the affix and suffix just adding that and getting the registration. But obviously it is depend upon what is the name, because sometimes the by adding the affix or suffix, the pronunciation of that name gives a complete different representation. So in that case, although there may be a chances of getting the registration.
Because it is a generic name, Sunrise. We are
Okay.
also using it, and one fellow from Hyderabad is also using it. He has registered it. So our registration application has been denied. So can we have, because we have different brands with the Sunrise with the a lot of suffix. So can we register that name at least like that?
Yes, you can, but I'm again saying that I can comment on this when I will means understand the names actually, means what suffix you are adding and what are these names. When I get to know those names, then
Okay,
only I can
we
comment.
will have one-to-one.
Yes, sure, no problem.
Ma'am, I have a question. Actually, I'm practicing chartered. So there are
But
certain startups.
your
Hello,
voice
am I
is,
audible?
yes, your voice is cracking in between. So yes, please tell me.
Am I audible now?
Yes.
So, ma'am, I'm a practicing chartered accountant in Indore. I just wanted to know that there are certain like startups or MSMEs who have inquired me for trademarks, and so just wanted to ask you that there is some portal fees for trademarks. So the fees that you have quoted 8,000 is only the professional fees that you are charging, or it includes portal charges also?
Yes, it includes total charges like government fees, stamp paper fees, and professional fees plus GST, everything includes.
And there is also case where the person who is undertaking all this trademark registration process also handles the appeals which comes while filing the application. So this charges includes those appeals also, or for that we have to.
Uh, No, I'm not understanding you properly. So what fees you are saying?
जैसे मैम जब भी एप्लीकेशन करते हैं ट्रेडमार्क की तो आई गेस न्यूज़पेपर में पब्लिश वगैरह होता है और सामने से अगर कुछ ऑब्जेक्शंस आते हैं तो उसकी अपील्स हैंडल करनी होती है एज फार एज आई नो.
यस तो अगर ऑब्जेक्शन आता है तो हम एग्जामिनर से रिस्पॉन्स करने के लिए अलग से फीस चार्ज करते हैं.
ओके
बट
ओके
दैट इज स्टेप वाइज फीस बिकॉज एवरी एप्लीकेशन डू नॉट गेट द एग्जामिनेशन. ओके, तो अगर एग्जामिनेशन आता है तो ही वो फीस एप्लीकेबल होती है, अदरवाइज ओनली वी चार्ज ओनली फाइलिंग फीस.
ओके 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 मैम, देन विल कनेक्ट सेपरेटली.
यस, श्योर. Yes, anyone else have some questions?
मैम राइट नाउ
Yes.
आपने अभी बोला कि कंपनी का फाइलिंग इज फॉर 8,000 रुपीज, बट व्हेन वी सी अपन जब पोर्टल में देखते हैं वो लोग तो 9,000 बताते हैं ना फॉर MSM, फॉर
Uh,
कंपनी एंड ऑल दैट.
it is, see, the fees can be different. Attorney, जो भी आप फर्म देखोगे तो फर्म का फीस अलग अलग हो सकता है. 8,000 मैं जो बोल रही हूँ वो that is including the government fees which are for MSMEs और for small entities, startups और individual. अगर आप large entity का देखोगे या MNCs के लिए जाओगे तो MNCs का गवर्नमेंट फीस ही 9,000 है.
हाँ, मैं उसी की बात कर रही हूँ. हाँ, उन
Yes.
लोग government fee-
Large entities के लिए गवर्नमेंट फीस 9,000 है, बट फॉर स्मॉल एंटिटीज और फॉर इंडिविजुअल्स द गवर्नमेंट फीस इज 4,500.
हाँ, अगर MSME सर्टिफिकेट है तो वो फीस 4,500 रहेगा, बट अगर MSME सर्टिफिकेट नहीं है तो 9,000 ही रहेगा ना.
यस.
ओके ओके. एंड अगर मुझे एक डाउट है मैम, लॉयर हूँ,
ओके.
एक ट्रेडमार्क एप्लीकेशन फाइल किया है, तो उसके रिगार्डिंग मुझे थोड़े डाउट्स है, तो अगर आप मेरे वो डाउट्स क्लैरिफाई कर सकते हो.
यस, आप मुझे पर्सनली बाद में हम अगर 1-to-1 करेंगे तो दैट विल बी बेटर थिंग.
वो मैं कैसे करेंगे मैम?
मेरा टीम आपको कैलेंडर का लिंक शेयर कर देगा, तो आप उसमें अपॉइंटमेंट बुक कर सकते हैं और उसके बाद हम 1-to-1 डिस्कस करेंगे, तो दैट विल बी इजी, सो इट विल नॉट बी वेस्ट ऑफ अदर्स टाइम। तो
हाँ
हम वो सेपरेटली हम डिस्कस कर लेंगे।
ठीक है, ओके, थैंक यू मैम।
यस, थैंक यू। सो एनीवन हैज अ क्वेश्चन?
हाँ मैम, मेरा नाम सुधांशु है। मेरा एक
हाँ
क्वेश्चन था।
हाँ
जैसे एक एक ब्रांड नेम रजिस्टर हुआ है वर्ड मार्क और लोगो के साथ, तो
ओके।
फ्यूचर में हम लोग लोगो में कुछ चेंजेस करते हैं, जैसे कि कुछ माइनर चेंजेस होता है, तो वो लोगो को क्या दोबारा रजिस्टर करना पड़ेगा और हम यूज कर सकते हैं नया वाला?
नहीं, अगर आप लोगों में कुछ भी चेंजेस करते हैं तो आपको अगर अलग से उसको प्रोटेक्ट करना पड़ेगा, क्योंकि ट्रेडमार्क प्रोटेक्शन जो आप बेसिकली फाइल करते हैं उसके ऊपर ही मिलता है, तो वो वर्ड है या लोगो है, तो जो डिजाइन एलिमेंट आपने फाइल किया उसके ऊपर आपको प्रोटेक्शन मिल गया। तो अगर आप उसमें कुछ भी चेंज करते हो तो आपको अगेन उसको प्रोटेक्ट करना पड़ता है सेपरेटली फाइल करके।
और जो ब्रांड नेम एज ए प्रोप्राइटरशिप रजिस्टर किया था, तो बाद में हम लोग अगर प्राइवेट लिमिटेड में जा रहे हैं, तो उसको क्या दोबारा प्राइवेट लिमिटेड के अंदर रजिस्टर करना पड़ेगा?
फिर आपको रजिस्टर करने की जरूरत नहीं पड़ेगी, आप उसको ट्रांसफर कर सकते हैं। यू कैन फाइल द असाइनमेंट एंड आप उसको प्रोप्राइटर से प्राइवेट लिमिटेड कंपनी पे असाइन कर सकते हैं।
अच्छा, और जो प्रोप्राइटर वही प्राइवेट लिमिटेड के डायरेक्टर हैं, तो ट्रांसफर करना जरूरी है क्या?
डिपेंड अपॉन यू एक्चुअली, अगर ट्रांसफर करना मैंडेटरी मैं नहीं बोल सकती, बट अगर आप प्राइवेट लिमिटेड जा रहे हैं तो इट इज ऑलवेज बेटर कि कंपनी के नाम से ट्रेडमार्क रजिस्ट्रेशन हो, बिकॉज देयर आर लॉट ऑफ थिंग्स गोज अराउंड द कंपनी नेम। तो आप जब एक प्राइवेट लिमिटेड होता है तो डायरेक्टर ऑफ होते हैं, तो बोर्ड्स ऑफ डायरेक्टर होता है, तो वो जो भी प्रोसेस होता है वो अराउंड कंपनी होता है। So it is always better to get the protection or get the name on the company's name. तो
अच्छा
अगर
अच्छा,
आपका
ठीक।
प्रोप्राइटर से भी रजिस्टर्ड है और अगर आप प्राइवेट लिमिटेड के लिए जा रहे हैं तो बेटर है कि आप उसको असाइन कर दे प्राइवेट लिमिटेड पे।
अच्छा, ठीक है, थैंक
यस यस
Ma'am,
यस।
I wanted to know the importance of digital signature. Is it mandatory to apply at the time of filing of the trademark? या बिना डिजिटल सिग्नेचर के भी हो जाता है ट्रेडमार्क एप्लीकेशन फाइल?
यू आर फाइलिंग मीन्स आप खुद से फाइल कर रहे हो, यू आर फाइलिंग इट बाय योरसेल्फ, देन द
Yes,
digital,
ma'am.
yes, then digital signature is required. Nowadays without digital signature we cannot file the application.
And it's going to be filed online only या फिर हम ऑफलाइन मोड में भी कर सकते हैं फाइल?
ऑफलाइन मोड में भी हम कर सकते हैं, बट नाउअडेज द ऑनलाइन प्रोसेस इज वेरी स्मूथ एंड मैक्सिमम प्रोसेस
Noted, ma'am.
ऑनलाइन
Noted,
ही
ma'am.
होता है।
Ma'am, one last question. How can we like for a proprietorship to register their trademark? उनका भी same process होता है as to the companies and other MSMEs?
Process will be the same for
Okay.
everyone.
Okay,
Yes.
ma'am. Thank you so much, ma'am.
Okay. Yeah. So anyone else?
Ma'am, this around 8,000 rupees you said, right? Actually, I have logo followed by word. So, is it to be something going to be additional charges, or both the things we can consider for registration, trademark?
Yes, yes, both the things we can consider.
Okay, 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 fine. Yeah.
Okay, okay, yeah.
Hello, ma'am.
Yes.
I want to register one trademark, but
Hmm.
this is a proprietary claim. But in the
Okay.
same name, another private limited company is registered. So there's any chance to avoid my trade, but that company not registered in trademark. But can I use that name? But they are not in my business, not in the same category. So
Okay.
any conflict will arise if I am applying for trademark.
It
But the same,
depends
I found one company name in the same name.
Okay. Okay. So you are saying that you want to protect one name and that is already there in existence with the some company's name, but they haven't filed the trademark, right?
Yes, yes.
And you now want to file a trademark application for your that particular name.
Yeah.
मैडम, पैटर्न के लिए भी ट्रेडमार्क कराना जरूरी रहता है क्या?
एक मिनट, मैं पहले उनके क्वेश्चन का आंसर देती हूँ, देन आई विल कम टू यू। या सो अगर आप अगर सेम नेम से कंपनी है एंड इफ यू आर फाइलिंग अ ट्रेडमार्क बट योर बिजनेस इज डिफरेंट देन यू कैन डेफिनेटली फाइल द ट्रेडमार्क बिकॉज देयर आर क्लासिफिकेशन देयर आर डिफरेंट क्लासेस फॉर डिफरेंट business different goods and different services so there are
Okay.
chances that two same names can be filed for two different classes.
Okay. If the same business, if there is any conflict.
It is depend upon that company, how much that company is big, how they are using that trademark extensively. So that is depend upon them. So prima facie, at this moment, I cannot comment whether there will be a conflict. But yes, you can file the trademark definitely.
Okay, that company is not very famous company, sir. Normal.
Sorry, I'm not getting you properly. Your voice is cracking.
Yeah,
Hello?
that company is a normal type of company, not very much well known.
Okay, okay. So there might not be any conflicts.
Okay, thank you.
Okay, yeah, yeah. Yes, Mr. Lucky, you were saying something.
मैडम पैटर्न के लिए भी ट्रेडमार्क कराना जरूरी रहता है क्या?
नहीं, पेटेंट एंड ट्रेडमार्क ये दोनों अलग अलग चीजें हैं. पेटेंट इन्वेंशन के लिए होता है, ट्रेडमार्क नाम के लिए होता है. अगर बिजनेस नाम है, प्रोडक्ट का नाम है तो उसके लिए ट्रेडमार्क होता है. सो ये दोनों भी अलग चीजें हैं पूरी.
ओके.
यस. Yes. Anyone else have some questions?
How can we search for a trademark? Is there any what is the website for that?
IP का website है, that ipindia.gov.in. So you can search on that website. There is a particular database for trademarks and you can go through that and search for your trademark.
Thank you.
Yes. Any other questions?
हेलो.
Yes, Mr. Nasir.
हाँ मैम, मैंने क्लास 35 के अंदर एक ट्रेडमार्क रजिस्टर किया हुआ है.
Okay.
डिवाइस के अंदर. तो उसके साथ मैंने एक टैगलाइन जो यूज की हुई है, तो मुझे वो टैगलाइन के लिए अलग से मतलब ट्रेडमार्क रजिस्ट्रेशन करना पड़ेगा या उसके साथ चल जाएगा?
टैगलाइन के लिए तो आपको अलग से करने की जरूरत नहीं है. आपने जो फाइल किया है उसमें आपने टैगलाइन नहीं डाला है, राइट?
टैगलाइन तो डाला है लेकिन नेम अलग से डाला है, और जब लोगो डाला है ना, लोगो के साथ टैगलाइन डाला हुआ है.
ठीक है, लोगों के साथ टैगलाइन है तो दैट इज इनफ. आपको अलग से टैगलाइन के लिए रजिस्ट्रेशन करने की जरूरत नहीं है.
एक्चुअली वो क्लास 35 के अंदर रजिस्टर हुआ है. तो अब रजिस्टर हो चुका है, तो उसके ऊपर ऑब्जेक्शन का कोई प्रॉब्लम नहीं आएगा ना यूज के बाद?
नहीं, अगर रजिस्ट्रेशन हो चुका है तो ट्रेडमार्क रजिस्ट्री की तरफ से तो ऑब्जेक्शन का कोई प्रॉब्लम नहीं है. अगर कोई थर्ड पार्टी आपको ऑब्जेक्ट करती है, आपको लीगल नोटिस भेजती है, तो दैट इज अ डिफरेंट थिंग. बट अभी ट्रेडमार्क रजिस्ट्री की तरफ से तो कुछ प्रॉब्लम नहीं होगा आपको. और आपके पास रजिस्ट्रेशन सर्टिफिकेट है तो यू हैव दैट एविडेंस कि ये ट्रेडमार्क आपने ऑलरेडी रजिस्टर करवाया हुआ है.
जी. और दूसरा एक सवाल था मैडम, अभी जो लोगो उसके साथ जो मैंने रजिस्टर किया हुआ था, तो पर्टिकुलर एक कलर के साथ किया हुआ था.
ओके.
अब वो कलर के अंदर चेंज कर सकते हैं या वही लोगो यूज करना पड़ेगा?
नहीं, आपको वही लोगो यूज करना पड़ेगा. आप कलर नहीं चेंज कर सकते. वंस यू फाइल विथ सम कलर कॉम्बिनेशन तो आपको वो कलर कॉम्बिनेशन भी प्रोटेक्शन मिलता है. तो आपको आप कलर चेंज नहीं कर सकते उसका.
अभी वही लोगो यूज करने के लिए अलग से रजिस्ट्रेशन करने की जरूरत नहीं है ना?
नहीं नहीं नहीं, अलग से नहीं करने की जरूरत है.
मतलब डिवाइस के अंदर रजिस्ट्रेशन किया हुआ था तो तीनों प्रोटेक्ट हो गया, मतलब टैगलाइन, नेम
यस
और मतलब लोगो.
यस यस राइट.
मतलब तीनों का भी अलग से कुछ करने की जरूरत नहीं है?
नहीं नहीं नहीं.
ओके मैडम, थैंक यू.
ओके ओके.
Ma'am, for registering a clinic, a medicinal clinic, will we get some concessions at the time of trademark filing या application के time पे?
Concession.
Yes, government concessions like you mentioned about MSMEs. तो इस classification में भी मिलेगा क्या?
कोई भी हो, आपको कंसेशन मिलता है एप्लीकेंट के टाइप पे. इफ एप्लीकेंट इज MSME, स्मॉल एंटिटी और इंडिविजुअल, then you will get the 50% reduction on that fees.
Okay. Noted, ma'am. Thank you so much.
Okay, yes. Anyone having some questions?
हेलो.
Yes.
और एक सवाल था मैडम मुझे.
जी बोलिए.
अभी मैंने क्लास 35 के अंदर ट्रेडमार्क मतलब रजिस्ट्रेशन किया हुआ था. अब मुझे मल्टीपल क्लास के अंदर उसको रजिस्ट्रेशन करना है, तो उसके चार्जेस अलग रहेंगे, मतलब किस तरह से करना पड़ेगा वो? यानी क्या उसकी प्रोसेस वगैरह क्या?
प्रोसेस होगा आपकी, जैसे आपने एक क्लास में किया है वैसे ही आपको जितने क्लास में उसको जाना है, हर क्लास में आपको अलग से फाइल करना पड़ेगा. और जितने क्लास में फाइल करेंगे उतना फीस, उतना मल्टीप्लाई हो जाएगा फीस.
ओके.
यस.
ठीक है मैडम.
ओके. So any other question?
How can we connect on for the registration process?
Yes, either my team will send you the link, calendar link, so you can book the appointment and then we can have one-to-one discussion and we take the things ahead.
Okay.
Yes.
Oh, fine.
Any other question? So in chat box, I'm saying Mr. Dinesh asking charges for objection, reply and hearing. So charges for objections are around 2,000 and charges for hearing will around be up to 5,000. Thank you, Mr. Pratik. He is saying that it was a very informative session. Thank you so much. So I think there is no other questions.
Hello, ma'am.
Yes, please.
Hello.
Yes.
Ma'am, you told me that if there's MSME registration, we can get some rebates, right? So for getting that rebate, you want to register MSME before applying TM, or if I'm already registered, can I get if I'm again registering MSME? So any chance to refund the amount?
You need to register it as a MSME before filing the trademark application. So if you have the MSME certificate, then while filing trademark application also you get the 50% reduction on government fees.
Then at the time of filing trademark, we already paid the fees. That time we don't have that MSME. Right now we have MSME. So any chance to claim?
Yes. If you have MSME, then you can definitely file that form. There is a MSME portal where you can get the forms. So you can file that, you can submit all the documents and you will definitely get the rebate from government fees, for the government fees that you have already paid.
Oh, very good. Thank you.
Yes. So thank you, Mr. Ram. And thank you, everyone. I think there is no further questions. So maybe we can wind up this session today. So thank you all for joining us today for this webinar. And thank you so much. I hope I have answered all your queries. And this was the insightful session. Thank you so much.